Now, I'm not sure that I want to get into this, Robert, because I'm not sure that you should, but it might be a good segue into the
all the Lin Wood problems. I think it's I still have, my criticisms of Lin are pretty public. I'm not a big fan of how they're weaponizing the Pro Hoc Vice process and the state bar process, though I'm not sure Lin is handling his defense in the most effective way either.
So for everybody, I guess the overview is that Lin Wood is now facing a number of ethical complaints. I think the one where he's been filed, I think it's the only one that's been filed thus far, is in Georgia. I don't know if they filed in New York yet, but
they have filed to revoke his Pro Hoc Vice in New York. They may challenge if he tries to appear Pro Hoc Vice on behalf of Sidney Powell in D.C. And they have brought a very large ethics complaint of some sort against him. He chose to publish it, which was interesting, but because otherwise those are confidential proceedings. But he published it. From his only licensure is from as far as I know, is from the state of Georgia, and he faces a very large ethics complaint there. And he was originally, they asked him to take a mental health exam. He refused. But the controversial part that's getting him into some trouble
is his crowd.
Yeah, go ahead.
Okay, so for those of you who don't know, it's look, I recommend against it all the time because it can be misconstrued and it can go badly. But so for everyone who doesn't know, he's facing an ethical complaint in Georgia. He publicly went out, and if anybody wants more detailed analysis on this, go check out Nick Rekieta, who's been covering this left, right, and center. Nick Rekieta is the Lin Wood complaint lawsuits channel. Although we do it once a week, Rekieta's on it sometimes more than once a day. So he has the ethical complaint in Georgia. He says now publicly, he goes on Telegram, I think it is, and says, they're going to go after me and test my fitness to stand as an attorney. I'm going to go after them and test their fitness to judge me. So all of you, and he's got a legion of followers, gather information about all these people who wish to judge me, and let's use that against them. From what I understand, also the biggest no-no you can possibly do, he posted addresses of the people on the board. So that is, I've got not just it. You could do that, yes. So so he did that, and now I don't know if it went bad, because he's got some dedicated fans and some dedicated followers, and people don't necessarily know what lines are not to be crossed, even in the context of a vigorous defense of an ethical complaint. But that's what he did. He basically crowdsourced to get damaging information on the people who are trying to get him disbarred. And then he published his complaint, which is a separate issue. But Robert, take it from there.
So that was used against him in the New York proceedings, as well as everything he did leading up to and on January 6th, where in the New York proceedings, there he's representing someone suing Joy Reid of MSNBC. I didn't write that. Somebody hacked my emails. Joy Reid, the sort of the same defense as the C-SPAN person. You can look into that and see whether you find it credible or not. But putting that aside, and she clearly seemed to me to have libeled someone, and the Second Circuit reinstated that case. But they're using the combination of what happened leading up to January 6th to try to get his Pro Hoc Vice revoked, the fact that the Delaware court revoked it, the fact that various sanctions motions are pending against him, and now they got to add to it the Georgia complaint because he decided to publish it, so that allowed them to include all of that in it, and then the fact that how he responded. And I think the problem is, my own view is, you're entitled to crowdsource information about, this has been contested in the criminal context. So there are people that will crowdsource information about witnesses, and you have to be careful how you do it. But the idea that you can't investigate whether someone's lying about you by crowdsourcing that has constitutional ramifications. So but the way he did it is going to probably be used against him, and it's already being used against him. And I think my guess is it'll be very hard if he's still licensed within a year. So I think that's just, and I've been saying all along, even though I've been a critic of Lin for quite some time, and for good cause, I believe. But the other point I've been making to him and Sidney Powell, and to some degree Rudy Giuliani, was that everything related to what they were doing was one big trap that was set up to not only discredit the election suits, but also to discredit them and destroy them. And unfortunately, they just never listened. particularly Lin, and now he's facing what he's facing. I think there is these are not. I agree with Nick Rekieta that the point of the licensure limitations and restrictions and suspensions and punishments should be predicated upon a client complaint, maybe a court complaint about something you did in the proceedings, but that would be it. It should not come from political opponents and political adversaries, like we're seeing in all the other attempts to cancel lawyers, cancel their jobs, cancel their clients, cancel their professorships, as you talked about this week. This does appear to be weaponizing the state bar and trying to set a precedent to go after political opponents, which they have done historically, but not to this degree of public attention. But on the flip side, I don't think Wood is helping himself with some of his defense tactics.
No, there's no question that what he did, if people want to call things dog whistles, some are easier to be called dog whistles than others. And going out on social media, on Telegram, and asking people, giving addresses is just, it's not ever going to be well received, and it could go even more serious than just being used against you. I mean, it can just lead to other complaints, of ethical and criminal nature. But first of all, actually, I just brought this up because it's nice. I watch your videos and streams a lot, but never guessed common law would ever hit me close to home. Recently, I learned my former classmate was extradited from UK and now waits for plea hearing in the US. I'm glad I've learned a bit from you both and understand what happened. Thank you very much. But getting to the actual complaint against Lin, because I've been reading it. First of all, I think it's terrible to weaponize the ethics body against lawyers you don't like. Some of the things that I would have criticism against, some of Lin's tweets, accusations against Chief Justice in particular, and VP. I know that these might be protected speech in everyday citizens, but when we sign up to be members of a bar, we do to some extent agree that we're going to suppress our otherwise inalienable freedom of speech somewhat. You have to show deference to the court, whereas a citizen will not get disbarred for telling a judge to go F themselves. But if a lawyer does it, you will. And so it's a limitation of free speech, but it's one you sign on to when you sign on to the practice. So some of the tweets, I think, were crossed a line. Some of the things that they're going after him for, though, seem like they are retrying lost cases in an ethics complaint, which to me is having a second trial based on insufficient evidence in a context that doesn't allow for a meaningful trial in the first place. They're going after his conduct in the suits. They're going after whether or not he disclosed, whether or not he served documents properly, whether or not he filed a court order that he was seeking to have obtained, a draft of the court order. In one of the cases, they're saying that he signed off on a lawsuit where the plaintiff said they don't have the right to represent me, and I never agreed to that. So in that particular example, I forget what the guy's name is, if he files a complaint, that would be a legitimate one. But in all the other stuff where they're just reassessing how he conducted the file and the probative value of the evidence that he filed, that doesn't seem to me, barring the most egregious cases of lying to the court, to be what the ethics panel should be used for. So, I mean, that's what I don't understand is how they go about that, to basically have a second trial for a trial that was lost, to say, not only did you lose that case, now it was so bad that we should retry you and have you dismissed or have you disbarred.
And especially not awaiting the judgment of those courts. So it's a problem of saying, well, he did something in some other court, and so we're going to punish him in this court without due process of law. And I think it's, and they're calling it due process. What the Delaware court did is not constitutional due process, in my view. And what they're asking the New York federal court to do wouldn't be constitutional due process. Once the pro hoc vice has been granted, due process applies before it can be taken away. But a lot of judges aren't aware of that. And I think that the complaint by the Georgia State Bar sort of jumped the gun. If they had a complaint from a court or a complaint from a client, that's where I think their jurisdiction is limited. Otherwise, it's a very precarious precedent to start politicizing these and weaponizing these ethical bodies to target political opponents. But it's clear it's what the left is going to do. Now, there's a history of it. If you were on the sort of independent left, independent right over the past 100 years, the state bar has often come after you. They went after, different, it wasn't state bars always, it was often courts, but those others too went after Clarence Darrow repeatedly. I think they tried to criminally prosecute him 3 different times. They went after Jim Garrison repeatedly. So there's just been an ugly history of how these, how easy it is to politicize these branches. But at the same time, Wood has made it easy for them to come after him and keeps making mistakes in his defense. So it will be something to watch because of the dangerous precedent it might set.
Well, I mean, the problem is, I think, a lot of it is throwing the spaghetti at the wall. You throw more than you need and hope something sticks. But I think they have a couple of good things which on their own might be sufficient for an ethical complaint in general. But the other question is, even if some tweets were over the top, even if, this plaintiff who never signed off on a suit has a complaint, where does it stop? What's the extent of the punishment? Is it absolute destruction? Is it a sanction? Is it disbarment from every state and no pro hoc vice? I mean, how far do you go with the punishment? Whereas if it were any other non-politicized individual, it might be a fine and it might be a 1-month suspension or whatever. Whereas with it looks like they're going to go everything in the kitchen sink after Lin for what might be legitimate sanctionable violations, but we'll see.
Well, the confessed felon Kevin Kleinsmith, to my knowledge, hasn't had any adverse action taken against him.
Well, politics ruined it. Where's my shirt? I had it. I took it off to put this one on. Politics ruins everything, and when it ruins the judicial and prosecutorial system, that is when people start losing faith. Robert, we just crossed 10,000 people watching live, and it is the good time to remind everybody we're at 2.2 thousand thumbs up. So hit the thumbs up. It's that little thing. Oh, look at that. I got an ad for this. Hit the thumbs up. The chat is always lively, so don't worry, leave a comment, but go hit the thumbs up and get it to 5 or 6,000, and that helps something in the YouTube system. Now, I wanted to get back to there is no more on Lin Wood. We'll see what's the time frame for what we should expect for a decision.
The Georgia State Bar I think will be a little while, but the New York pro hoc vice decision probably will come down pretty soon. They're also using his statements. He really should have representation in these proceedings rather than trying to represent himself. The old statement that a lawyer who has himself for a client has a fool for a client.
No, so someone who has himself. Yeah, I don't know if it's a lawyer, but whoever.
Yeah, I always add the lawyer version because I think a lot of people can represent themselves pro se effectively sometimes when they can't afford a lawyer. So I'm not as dismissive of pro se people as the court system is. But definitely when a lawyer has himself as a client, because a lawyer of all people should know that's not likely going to work out well. They're also using statements that he made to claim that he made false statements to the court. He's giving the court an easy hook to deny him pro hoc vice appearance based on representations he made about what he did and didn't say on January 6th, because he said some very problematic things on January 6th as the events were unfolding.
No, so we don't need to repeat them. We want to not push any envelope, but everyone can know what they were. And Nick Rekieta does a good job actually referencing and showing images. Okay, before we get to the next subject, I want to read one chat which I brought up, but I didn't read it out loud. Matthew Zollinger says, "Hey, my wife needs some support this week. She graduated from law school and helped me beat cancer and needs some Barnes and Viva love." Matthew, double congratulations.